And in this, and good old friends like Lakshmi from Hyundai, wherever I am there, she is there. So thank you for following me. So now I am dealing with the two labor codes. One is Industrial Relations Code and the other is Occupational Safety and Health. So as the speakers have mentioned to you, about 39 labor laws are now going to be subsumed into 4 labor codes. So these 4 labor codes, mostly what this government of India has done and other states have done, just copied and pasted many of the old existing provisions. Very few amendments have now brought in, but all those new amendments are going to create more confusion than the existing one. So, and there is a likelihood of much litigation also because of the introduction made by this in the some of the provisions in labor codes. Now I will take you to the few of the important. Rather, I am given 1 hour time to cover 2 codes. Each code requires at least half-day session. So that I have compressed into 1 code to make it to a 1 hour program. That editing has taken a lot of time, Sujata Garu, instead of preparing it. So editing has taken a lot of time. So I will try to cover as many as more important amendments which are brought in this code, and the rest of the codes were taken in the afternoon session by Ramchandra Rao Garu. So we'll start, man. Okay. So 29 labor laws are now rationalized into 4 labor codes. One is first passed in 2019, that is Code on Wages. That the Code on Wages now going to replace Minimum Wages Act, Payment of Wages Act, Payment of Bonus Act, and Equal Remuneration Act. All these 4 acts now will be called as Code on Wages 2019. Please remember, this passed in 2019 itself. It's almost 5 years old. And the rest of the other 3 codes are in 2020. The Code on Social Security, which replaces ESI Act, EPF Act, Gratuity Act, Employees Compensation Act, Maternity Benefit Act, and BOCW Act. And similarly, the Occupational Safety, which now I am dealing, replaces Factories Act, Contract Labor Act, apart from another 13 acts. So total 29 acts, books are now compressed into 4 books. That is what physically going to happen. Now almost all the states have prepared draft rules on the 4 labor codes, including the states of Telangana and Andhra Pradesh, and few others are in the process of doing and framing the draft rules. It is only draft. Finally, it has to be prepared by the respective state governments. All these codes are passed by the parliament, both the houses of parliament, and the president has given the assent, and only the effective date has to be notified by the government of India. We are waiting to notify the date, that's all. It will come into effect as soon as the government of India notifies the date, and everything is been done. So the government of India may also notify date after all the states have prepared their draft rules. So that is where now the labor code stands. Now, as I mentioned it to you, the 3 enactments which are now existing are going to be replaced with IR code. And interestingly, this code is going to apply for the entire state of whole country, including the states of Jammu and Kashmir. Earlier, if you see any preamble of any enactment, you will see it does not apply to the state of Jammu and Kashmir. Now, after Article 370 was abolished, this is the first law which was made applicable to including the state of Jammu and Kashmir. So this is the Industrial Relations Code 2020 is going to apply even in the states of Jammu and Kashmir. So that is the only state. On a lighter note, the judges coming from the Jammu and Kashmir does not know any law because no law is applicable in Jammu and Kashmir. It is an interesting joke on the judges who came from Jammu and Kashmir to the Telangana and Andhra Pradesh, who used to joke with those fellows that you don't know any law. All the laws are exempted. How can you practice in law? That is what happened with Jammu and Kashmir, sir. Now it is going to apply. Now, this is the interesting amendment, which is many of you are being, otherwise also now being followed. Now, first time a legal sanctity is given for the appointment of the persons on fixed term employment basis. Now, the ingredients are, which is the primary requirements to have this fixed term employment is, you have to have a written contract, some kind of an employment letter, an offer letter, or an appointment letter. Written contract should be there with these fixed term employees. And his work of the duties, wages, and other benefits shall not be less than a permanent workman. On the guise of employing an FTE, you can't put him in a different role at a less than what the regular employee is being paid. This is not to evade the existing system. You have to engage him on par with the regular employees. So that you have to do. The other thing is all the other social security laws like ESI, PF, gratuity, if applicable. All these things will apply. And only rider which is added here is he is entitled for gratuity if he completes 1 year service also, which otherwise 5 year service is required for a fixed term employment under this code. Is only after 1 year we have to pay him a gratuity. If you call it as a gratuity or a service compensation, whatever, we have to pay him 15 days wages even for 1 year of service. That is a new concept which was brought into this. Now a worker is also changed. Earlier it is workmen. Wherever you see any of the three core laws, ID Act, Equal Remuneration, Trade Union Act, you will see workmen. That definition is now removed and it is called now as a worker. It includes male and female. So anybody is now a worker. And except is the managers who are in supervisory capacity. Those people are excluded. But now the salary limit is increased from 10,000 to 18,000. So 18,000 salary who is having a supervisory and managerial powers are excluded from the purview of this code. Otherwise, everybody is covered. So in view of the amendment made like any person, it includes contract workers also and includes sales promotion employees and working journalists. So this was made because they want to brought into the purview the print media, electronic media. Those people are earlier covered by the Working Journalists Act. So that Working Journalists Act also not covering the print media people and electronic media people. So they don't have any protection. So to give the more protection to the journalists, they have brought into the purview of this code also. So subject to these limitations, even the sales promotion employees and the working journalists are also covered under the IR code. So that is the major change to make them benefit. And the gig workers are brought under the coverage. Similarly now, the working journalist and sales promotion employees are also given the benefit of some protection. Now these next 3 slides are more confusing. And next 4 codes, this is the only issue. Sir will take it from here. PF. The main focus is now going to be because on PF. This definition is going to impact your PF contributions, your terminal benefits, and all your statutory payments is now going to be governed by these next 3 slides, which is wages, which is common in all the 4 codes. In all the 3 codes, including this IR code, this is the definition for the wages, and you have to revise your salary structures according to this definition now. Now you see the definition. Wages means all remuneration, whether by way of salaries, allowances, or otherwise expressed in terms of money, be payable to a person employed in respect of his employment and include basic salary, dearness allowance, and retaining allowance. These are the 3 only conditions going to be included in the definition of salary. Exactly this is the definition under section 2B under the PF Act. Am I right, sir? Yes. So this is the definition under the PF Act, copied in from the PF Act and pasted into this code. So this is the definition of the PF Act originally existing. Now you see, by making that copy pasting, they have created a lot of confusion into this. So except these 3, about 10 points they have mentioned, which does not include into the wages. You see, the does not include bonus, value of house accommodation, contribution paid to the pension fund, conveyance allowance, some paid to the person employed to defray special expenses, house rent allowance. This is the important thing which is going to affect on our PF. Whereas so far, now HRA is excluded under the PF contributions. Now they have removed that. So this is a wage, it will not include the HRA now. And then the remuneration paid under the any award and settlement, overtime allowance, commission payable to employee, gratuity payable to an employee on the termination of employee, and a retrenchment compensation or other retirement benefits. These are all the things which are excluded from the definition of wages. So what remains is basic DA and retaining allowance. Retaining allowance, nobody of you must not be paying now. That why the government of India brought that retaining allowance, nobody knows. This is there in the PF Act only. Retaining allowance generally will be paid in a seasonal industries to retain the workers to the next season. In the off season, like sugar, cotton, tobacco, where the season ends, to keep the workers for the next season, they will pay some retaining allowance. So that kind of a retaining allowance nowadays nobody is paying. No seasonal factors nowadays, everybody is working throughout the year. So the concept of seasonal factor gone, but still this retaining allowance is still being continued. This is unnecessarily that clause is now continuing. So now you can see the other thing. This is the important provision. Provided that for calculating the wages under this clause, if payments made by an employer to the employee under subclause A to I exceeds 1/2, that is 50%, or such other percent as may be notified by the central government of all the remuneration calculated under the clause, the amount which exceeds one such half or the percent so notified shall be deemed to be the remuneration and shall be accordingly added to the wages under this clause. So A to I have shown you house rent allowance, commission. So those allowances, if exceeds 50%, it will be added to your wages. So how foolish, I will tell you. If a salesperson in a BMW or Benz or an Audi showroom, that fellow will get 1 lakh commission on a sale of a good vehicle, about 3 crores vehicle. He will get 2 lakhs or 3 lakhs as his commission. So if he gets 3 lakhs amount, that will be added to his salary. So the commissions always differ. Some month he may get, sometimes he may not get. And in the festival season, the employees may get some other incentives. Those things will keep on varying. But still they have added that these positions also to be included for the purpose of calculating the wages every month. So that is how the issue is now as on today. Now I will show you what remains exactly now. This is the ultimately what is the losses. Wages, included wages components are basic dearness allowance and retaining allowance, whereas the other components which are excluded are HRA, conveyance, remuneration, paid under the award or settlement, gratuity and bonus. So these are the three included components and the others are all are excluded. So if included component is less than 50, then 50% of gross to be considered as your wages. You please take it to the next sessions also. This is the, on all the 4 codes, this is the principle. Wages in all the codes is 50% of your gross should be your salary, on which you have to pay PF, ESI, all other benefits. So if you pay basic and DA less than 30 or 20 or 40, many companies are following different pay scales. Now you have to make it to 50%. You can't pay less than 50% as your basic and DA, and it should be 50% minimum. On the other 50, you please be careful that other components will not reach that 50%, not exceed. So what is the impact of this change? On certain components, you are going to save some money. And in somewhere, it is going to cost us. The implications are, all monthly paid allowance should constitute only 50% of the total monthly remuneration. And the other is layoff compensation. If many of you are from any manufacturing sector, they have more exposure to this layoff, closure, retrenchment and all other things. IT people generally don't have this kind of background. So layoff, retrenchment, closure is under the ID Act. So wherever that compensation is now paid, earlier it was to be paid on gross, now you can restrict it to 50%. So that is the advantage now. And retrenchment and closure compensation will reduced. When basic and DA is less than 50, then it is to be increased to 50%. As I mentioned it to you, if your basic and DA is 30%, 40%, you have to recalculate and redo your policies to make it as 50%. 17B wages, whenever the employee terminated, we will pay last on wages. That last on wages is now going to be reduced. 1 month salary notice pay under section 33 will be reduced. So far under the ID Act, we are paying on gross. Now that is to be reduced into 50%. That is the saving because of this new code. Now for the first time, IR code mainly useful for the manufacturing sector people. This because deals with ID Act, Trade Union Act and equal remuneration. Other sectors may not have the major impact because of this. So the strike is also slightly modified and the new clauses have brought into this purview. It includes concerted casual leave on a given day by 50% or more workers employed in an industry. Applying for a mass casual leave by 50% or more is now amounts to a strike, which generally happens in government sector. People will go on leave. Generally, we will not see that kind of a tendency in a private sector. But now it is called as a strike. And then go slow. Earlier, it was not at all a misconduct. It was not considered as any issue under the ID Act. Now it is added as an unfair labor practice, not as an offense. But still, it is an unfair labor practice if go slow is adopted. No person shall go on strike without giving the employer 60 days notice and within 14 days after giving such notice. This is earlier was there in the public utility services. The concept of public utility is now removed. Everybody is a normal industry, including the government sector. So whoever wants to go on strike, 60 days notice to be given, and within 14 days of giving such notice, they cannot go on strike. That is the new introduction in this. Now, for the first time, there is a grievance redressal committee. Earlier, there were works committees. This is replaced by grievance redressal committee. And this committee should consist of maximum 10 employees. Whether it applies to software company, whether it applies to the manufacturing sector or a service industry, everybody has to govern this now. All of you, wherever 10 or more workers are employed, now everybody has to constitute this grievance redressal committee. And maximum number is 10 workers and proportionate representation to be given to the women in this committee. And then earlier section 9(6), which deals with the work committees and other things, is now repealed. There is no works committee now, it is only grievance redressal committee. What this committee will do is any worker who have some kind of an issue with the management or with his co-worker or any issue, he has to approach the GRC with his grievance, and the GRC should decide such case within 30 days. All the things, yes sir.
Those committee recommendations were not binding.
Yes,
This will be
binding. Now that is the importance given to the GRC. This is binding. Any worker who have any kind of an issue has to approach GRC with his grievances, and it should be decided within 30 days. And the decision of GRC shall be on majority view, provided more than half workers members. Majority view will provide generally whatever is majority accepts. And application by an aggrieved worker can be submitted within 1 year from accrual of cause of action. Every time all the labor courts have given, that is a new good gesture of government, is everything now the limitation is being prescribed. For everything there is a limitation. That is the only good thing which we can see. Otherwise, workers are raising disputes after 10 years, 15 years. Somebody goes to Dubai, do some work there, come back, and file the cases saying that I am illegally terminated about 10 years back. These are the cases which we are handling. So those kind of issues are going to be arrested. And now there will be clear limitation for everything. So within 30 days, he has to raise a dispute with me on the JRC, and within 1 year, he has to raise that claim before the JRC. And worker aggrieved by JRC decision may approach conciliation officer within 60 days. Everything by limitation. So that's all majorly we have captured under the ID Act. Now we will see how trade union is going to change because of the IR code. Many interesting changes in this. Recognition of negotiating union or negotiating council. There is now going to be a negotiating council instead of a trade union. Any of you are handling the trade unions here? Oh, quite good number of people. Thank you. So therefore it will be more interesting for you. So what happens now because of this code introduction is, when there is only one registered trade union, you shall recognize it. There is no option. Mandatory now. There is no contest. One body has majority and others don't have majority. Those issues gone. When there is only one union, you shall recognize it. And when more than one registered union, trade union is functioning, the trade union with 51% of more workers on the muster roll shall be the sole negotiating union. When the other unions have, whoever have 51% or more, will become the sole negotiating council. The issue comes, if no such trade union has more than 51% more, the employer shall constitute a negotiating council consisting of representatives of such registered trade union which have support not less than 20% of total workers, and shall be one representative for each 20%. Is it not complicating the issue? When there is no trade union, every 20%, one person will be there. That persons will be called as negotiating council. And they will represent to the management, and they will discuss about the charter of demands or any other issues. Instead of a trade union, now there will be a negotiating council. And this will be the difficulty in where multiple unions are there. All public sector, there are 7. Every political party has one wing of a trade union. BMS, INTUC, AITUC, everybody has got a wing. So when these 7-8 trade unions are functioning in one unit, there will be every 20 will have one member there. So discussing with so many members and finalizing the charter of demands or wage settlements will be very difficult for the management now. Earlier it was only one, whoever win the election. So that fellow will be the sole bargaining agent. Union? Elections. Elections is now, only one is, if otherwise, whoever wins the election, that will be continued. No, that is under the code of discipline. The code of discipline gone now. No discipline. So that is the difficulty. And one good thing what they have done is trade union membership they curtailed. Earlier if you see, Uppal Industrial Area Workers Union, Nacharam Area Industrial Workers Union, Building Constructions Workers Union, they are not connected to any particular industry or an organization. General. Those people used to raise any dispute, and management are asked to produce the records, asked to answer those questions, even though none of the workers are members of that unions. So that kind of issue is going to be arrested now. So the members can only the persons actually engaged or employed in the industrial establishment, undertaking or industry or units, branches or offices of industrial establishment with which the trade union is connected. This is the contention which we are raising, sir, for so many years. Well, Ramchandra Agar comes, he will tell you, we were GMR Airport Workers Union. That was the one association formed, sir, raising disputes against Ramchandra Agar. Ramchandra Agar was supplying the manpower to the GMR Airport. And some union is formed in the name of GMR Workers Union. Who are the office bearers? Some ex-councillor of that area. Somebody, some political party, all outsiders who are not connected with GMR Airport. And they raised an issue that the cab driver should be given that much the porters should be given this much, and inside that people who are assisting the other activities should be given this much. Like that, they are given a demand. Unfortunately, Labour Department entertained that dispute. With due respect to Chandrasekharam Garu, he is the person which we fought. How can you entertain this kind of a dispute? Who are they? That there are several contractors. Indigo engages 100 contractors in Hyderabad airport, sir. 100 contracts for handling, for removing, then the aircraft pulling. 100 contractors are there. That contractor also not aware about who is this trade union. So that kind of trade unions are formed. Now it is stopped. All my old friends knows how the trade unions dominated, how the outsiders have dominated the issues. So that kind of activity is now going to be stopped because of this membership restriction. And also the admission of honorary and temporary members who are not workers are not permitted. Now honorary president, Mr. MLA so-and-so, honorary secretary, honorary vice president, Sangareddy MLA, Nayan Narasimhareddy. Meekandariki telusu. He was the minister for labor and he was the president of so many unions. Meeku telse untundanta. So that how the old timers have dominated the issue. Now slowly there is no real trade union leader who actually knows the law. There is no trade union leader. As on date, nobody survives. All of them gone. So therefore, now what happened is even the outsiders cannot be taken as honorary and temporary members also. Only the persons who are employed in the industry should only be taken as members. And the ministers, persons holding the office of profit, cannot be the office bearers of the executive body of the trade union. So they cannot be office bearers. That provision is already there, existing provision, that one. But still they made it clear. And now, earlier, when there is a dispute between two unions, we used to go to the civil court and say this election is not well, that voters list is not properly done, the finalization of done is not properly done. Those kind of issues will go before a civil court and then to the high court. Now, interestingly, they have changed this, giving each worker to raise a dispute. Any worker can go and say that this union election is not properly done, this maintenance is not properly done, accounts are not properly maintained. All these things can be raised by a single worker. As per section 22, any dispute with one trade union and another or between the members of trade union, including the elections of office bearers, the industrial dispute has to adjudicate the dispute. Industrial tribunal earlier has no jurisdiction to this matter, sir. Now they are given. The Subramanian Garu was the chairman earlier for this industrial tribunal. One or more workers who are the members of a trade union can make an application for adjudication. Even one worker can make an application regarding registration, administration or management of election of office bearers of trade union. So this is going to be a big issue. And the power which they have given to the trade union is enormous. A trade union can ask for your balance sheet figures, whether you are maintaining your balance sheet correctly, whether those entries are right, whether you have manipulated that. All these things can be asked by a trade union. In contrast, earlier the provision of law was, when a balance sheet is audited by an auditor, it is presumed to be correct. You cannot raise a dispute about the audited balance sheet. Everybody, including the Labour Department, when the audited balance sheet is produced, they cannot question the validity of that balance sheet. That was the presumption, is everything was properly audited. Now, a power was given to the trade union or a worker to ask, requiring any clarification relating to any item in the balance sheet or profit and loss account. So this is going to create a lot of issues where trade union activities are more. Generally, that kind of power should not have been given.
What is the intention of giving such powers? Like an own interest?
nobody knows here. Somebody sit there. Somebody taken some view from somebody, just pasted here. They have not made any examination, not consulted any of the employers' representatives. Only some of the trade union leaders who are powerful in their politics background have influenced to add this kind of things. This position has taken from Maharashtra Unfair Labor Practices Act, MRTU. Those provisions are there. Except in Maharashtra, there is no such provisions earlier in the entire country. Now this is copied and pasted from that. So entire 4 codes are copied and pasted. Nothing is there. Except adding few things here and there, many of the provisions which are existing are pasted here. That is the difficulty. Why after 100 years of making this law, still they have done the same thing. So 1926 is the Trade Union Act. And then 1948 was the pre-independence. Many of the acts are pre-independent acts. When after 50 years we are changing the whole, revamping this, they must have done it in a better way than this copy pasting. So it is not answering to the present day requirement. That is a difficulty. Moonlighting is there. Many software is there. Moonlighting is not answered. How it is to be handled in a proper way. Breach of contract. Every software company employees are jumping from here to there. How to, whether that can be restricted, whether there is any provision for that. Those things must have been answered in a better way, while they are totally changing the labor laws.
Sir,
Yes, sir. Yeah.
these courts cannot be amended anytime.
For sure, it is going to be challenged in many courts. There will be huge litigation on this. So we are happy and we are waiting for that to come. Definitely. Already some advocates drafted this petitions to be filed, sir. They kept it ready. That is how the system works. All lawyers can form a union. So these things are, now that is all trade union, and because I am touching each act, important 4 slides from each act which have earlier was mentioned in the 3 acts. Now we will see the standing orders. Now it is only advantage now, it has made 300 workers. If you are below 300 workers, standing orders are not required. Earlier it was 100, now it is made 300. So 300 is the minimum limit. And then, if the standing orders are not certified under the code, the model standing orders shall be deemed to be adopted. It is in existence present also. Where employer adopts model standing orders of the central government, such model standing orders shall deem to have been certified. There is a central model standing orders and state model standing model. If you adopt central, that deemed to have been adopted, certified. You get no need of going for any certification. The existing standing orders will be deemed to as certified as standing orders under the code, so far as it is not inconsistent with the provisions of this code. And a group of employers, this is a new introduction, a group of employers in similar establishment may submit a joint draft standing orders for certification. A group can also, suppose in an SEZ, and wherever units are common.
I didn't understand.
So the joint standing orders can also be submitted. So industrial tribunal, and one comment is the labor courts which are now functioning effectively for the last 80 to 90 years, sir. And it has stood up to the time. Labor courts have functioned enormously with great composition, either for workers or for the managements. Those labor courts are being abolished. What is the reason for abolishing that labor courts also? Nowhere any justification was given. And instead of
I just want to say that the presentations will be shared with everyone later, so you don't have to worry about taking photos and everything. So.
Yeah, it will be circulated once this presentation is over. So this, instead of labor courts, now there will be industrial tribunal with 2 members. Strictly speaking, there is no need of having 2 members for an industrial tribunal. A RTC driver, whether he conducted 10 rupees or more in a bus, is it to be required by 2 judges to be decided? A worker absent for 15 days when he was terminated, is it to be required to be decided by 2 judges? Very simple issues which are going to be before a judge is unnecessarily given to 2 judges bench. There is no such complications involved. In tax matters, in the land matters, where there is some kind of a technical issues will be involved. In such cases, generally another administrative member will be there apart from the judicial member. So, but whereas you are a labor court or a tribunal, mostly about the termination cases, he is absent, he abused, he went on a strike, those kind of things can be decided by a single judge, which has been done for the last 100 years or more than 50 years. Now they have made it a 2-member bench. And the power is given to the granting interim relief in case of any employee is terminated. Such kind of an interim relief power is not given to the management. So only worker can got an interim relief if he was alleging before the tribunal saying that I am illegally terminated. He will be given by the court a stay order or something, not to terminate him. Then what happens will be a big issue. And no power to the grant interim relief to managements. So such power should also be given to the management. It should have done that. And the decision of the tribunal shall be always by consensus of both members. And other matters can be heard and decided by a single judge judicial member or single administrative member of the tribunal. So that are the powers of the tribunal. Not time అయిపోతుందా sir? Thank you. And just checking the time limit also. So the layoff, retrenchment and closure is now made 300. Below 300 employees, wherever you are having, you can retrench, you can close down your activity or you can lay off the workers without taking from the government. Earlier, when 100 or more workers are there, you have to take prior permission from the government, then only you can declare a layoff, retrenchment or a closure. Now that prior permissions are not required. You can close down your organization, you can retrench workers, you can lay off the workers. If you are below 300, that is one big relief given to the small kind of other MSMEs and other things are getting affected otherwise. First time a worker reskilling fund is introduced. The appropriate government shall set up a fund to be called a worker reskilling fund, and the employer shall contribute 15 days wages of the workers who have been retrenched from service. Now this is an additional burden on the managements now. Apart from paying his terminal benefits, you have to contribute another 15 days to this worker reskilling fund. Whenever you terminate or close down or you lay off, this is an additional burden on the management. And the other matching contributions will be collected from such other sources as prescribed by the appropriate government. So the funds will also be collected to make this fund more vulnerable. And first time, and the compounding of offences is being introduced. So they want to save the managements, Gujarat managements. So they have introduced this compounding of offences. So whenever a criminal case is filed, including PF department also will file cases against the employer for non-payment of contributions in time, employees share deducted but not paid. Those things, when the criminal cases under any act is filed, you can pay the fine and avoid the court litigation. Otherwise your MDs, your occupier, your managers has to stood before the magistrate court. Now that it can be avoided by paying the compounding fee. This is one good thing which they have introduced, particularly under the Factories Act. There will be, when in case of a death, accidental death, there will be definitely a prosecution against the occupier. Occupiers are always will be your directors or your managing directors. So they have to stood before the magistrate court to face the prosecution, particularly under the Factories Act. Now, by paying this 50% of the fee, fine as a compounding fee, you can save the prosecution or you can save the facing of the court. That is a one good introduction in this. That's all about the IR code. Any questions on this IR code, sir? We will have to cover the second code also now. So on IR code, if any issues, we will discuss, and I will go to the second code. Yes, sir. Elections will be continued. Yeah. Yes. If nobody gets 51%, there will be every 20%, there will be one member.
Various unions. Huh?
Yes.
Okay. Thank you.
Correct. Okay. Shall we go to this occupational health and safety? This is nothing much in this code. Almost all the provisions which are there pasted here in this code, except one act which is Plantation Labor Welfare Act or something, that is totally repealed. Rest of the provisions on the existing with slight modifications and pasted in this code. The code proposes to subsume 633 provisions of 13 major labor laws into one single code with 143 provisions. 46% reductions in registrations and license related compliance resulting into consolidated database centrally. 21% reduction of prior laws resulting into dynamic legislation as compared to the existing sectorial approach. The code provides single registration for an establishment instead of multiple registration. This is one advantage. You can have only single registration, Contract Labor Act, BOCW Act, Factories Act. So multiple registrations can be avoided. You can take only one license. That is sufficient. That is the major thing. Now these are the 13 acts which is going to be replaced. Factories Act, which is 1948, covering the safety, welfare, and health of the workers, is totally repealed, but pasted here in another form. So the Factories Act, Mines Act, Dock Workers Safety and Wealth Act, Building and Other Construction Workers Act, Plantation Labor Act, Contract Labor Act, Interstate Migrant Workers Act, Working Journalist and Other Paper Employees Act, Working Journalist Fixation of Rate of Wages, Motor Transport Workers, Sales Promotion Employees, BD and Cigar Workers, and Cine Workers and Cinema Theatre Workers Act. All these 13 acts are now going to be replaced with this OSH code. So we'll see what in this major changes is the definition of contract labor has been modified and includes an interstate migrant worker. Earlier there was a dispute. Suppose an employee who came from Bihar or Orissa came through a contractor, whether he can be considered as a contract worker or an interstate migrant worker, or both apply. That kind of a confusion was there. We are taking a stand, interstate migrant was not applicable because he came as a contractor, through contractor. So that wasn't as issues now are answered. Interstate migrant worker includes a contract worker. All factories, as our Rajiv Khosla said, many of the workers are from other states. They are all interstate migrant workers. So the contract labor includes a interstate migrant worker, but excludes the part-time employees, and employees who are regularly employed by the contractor for any activity of establishment are entitled to Social Security. The new definition of core activity under this Contract Labor Act, all the earlier erstwhile state of Andhra Pradesh has been appreciated by entire country, sir, because of making this amendment in 2003 while Chandrababu Naidu was the Chief Minister. That's a great thing. You remember that? That was the 2003. Only the AP government during that time made this kind of an amendment. Now that amendment has been pasted into this code for the entire country. Earlier, it was perennial and non-perennial issues. Now the Chandrababu Naidu at 2003 was first time was made this kind of an amendment for the Contract Labor Act, allowing the contractors to engage anywhere. You can engage workers in non-core activities anywhere. Because of gardening, canteen, security, housekeeping, everything is because of that amendment was brought in 2003. Earlier that was not happening in the state. Because you are regularly, housekeeping, you are regularly working, engaging them. How can you engage? You can't. Security, you are still every day you require, you can't engage. That was the position of law earlier to 2003. When this amendment was made, everybody be given a free hand to engage a contract labor. Because of that, employment has been increased like anything, particularly in erstwhile Andhra Pradesh. Now this provision is taken as a clue and pasted in the code. So it is going to apply for the entire country, which says that in certain core activity also you can engage a contract labor. What is a core activity is again an issue. So employee includes managers, supervisors, etc. Employers include managers, occupier and a contractor, and the duties of employees are defined. Now first time, what is the duty and what is the right of an employee is also defined. Earlier it was not there. So one registration, this is only one big advantage. Any establishment employing 10 or more workers shall make an application for registration within 60 days from the date of its applicability. Contract Labor Act, BOCW Act, Factories Act, whatever. You can have to make an application online, one single application for all these acts. Instead of multiple registrations, which is now required under 6 acts, namely Factories Act, Contract Labor Act, BOCW Act, Motor Transport Workers Act, Plantation Labor Act, and Interstate Migrant Workers Act. All the 6 acts, you need not take different licenses. One license is sufficient. If not approved within the prescribed time, then such establishment deemed to have been registered. Timelines, as I mentioned it to you, everything is now by timelines. So within these 60 days, if the government does not approve, it is deemed to have been approved. So that is one advantage. And notice of closure of establishment to be intimated to the registering officer within 30 days. And the registering officer shall make an amendment in the certificate of registration electronically. If not approved, the amendment within the prescribed time, it will get approved automatically. So that is the factory is closed. There is a lot of process to cancel that registration. Now they have made it a timeline. Once you upload it, your cancellation. Within 60 days, if they don't approve, you are deemed to have been given permission. That is the advantage. Shrama Suvidha portal they are mentioning. It will go through Shrama Suvidha portal. Everything through Shrama Suvidha. No individual offices. So first time a right of employees are given, mentioned. And what the employees' rights are, he can be asked for what is the medical facilities you are giving to me. What are the leaves I am giving to me. It should be made applicable for FAPSI also, ma'am. What are the facilities I am getting and what are the leaves I am getting. And when there is a reasonable apprehension, there is a danger likely to happen in chemical and pharma companies, he can raise a dispute about that. My life is in danger. So that kind of a right the employee has been given under the code. And if such issue is raised, the employer or the employee shall take immediate action if he is satisfied about the existence of such imminent danger and send a report forthwith of the action taken to the inspector cum facilitators. Now there will not be any inspector of factories, labor commissioner, there will be facilitators. They will be redesignated as facilitators. So me designations atlage untunayi marutunayi. Meevu atlage unnayi. Yeah. So welfare facilities in the establishment is slightly changed. Employer shall be reasonably provide and maintain establishment such welfare facilities for the employees as may be prescribed by the central government, including washing facilities, locker rooms, restrooms, adequate first aid rooms. These are all existing. Now, facilities in canteen establishment where 100 or more workers, including contract workers. Now existing 250 workers is required to maintain a canteen that is reduced to 100, including contract workers. So if you have 100 workers, you have to provide a canteen. Many. So leave with wages also slightly changed. Earlier 240 days is now reduced to 180 days. So the eligibility to get earned leave earlier was 240, it is now reduced to 180. That is one advantage. And the employment of women is slightly changed, all soft. Yes. Earlier 240, it is now 180 only. No change, Amma. Only that limit has changed. Yeah. So for women workers also, there is slightly an relaxation is given. No woman shall be required to allowed to work in a factory except between the 6 a.m. to 7 p.m. What the change has been now is, provisions has been made with the employment of female employees working beyond 7 p.m. to 6 a.m. with their consent. If the woman employee give the consent, you can engage them even in the night shift also. But without their consent, you can't engage. Providing safety and then transportation, that is all other things. But taking consent from a woman employee is mandatory now. And section 44, if the appropriate government considers that the employment of women in any establishment is found to be dangerous for the health and safety of women, then the employer may be required to provide adequate safeguards. That's what providing safety, transportation and other things. And crutch facility is also slightly modified. Now what this again stands inconsistent with the Maternity Benefit Act. Many of you are aware about this inconsistency, and again it is going to be continue in the same fashion. The limit of female workers for purpose of creating a crutch facility for the children below 6 years of age would increase 50 female workers from 30. Now it is clearly defined 50 female workers. Earlier it was 30 workers. Whether it is a female or male or how it is to be calculated, that was a big issue. Now they clarified that 50 female workers having 6 years below age children, then there should be a crutch for them. And an establishment can avail a common crutch facility of the central government, state government, municipality or any private entity provided by the non-government organization or by any other organization or group of establishment may pool their resources for setting up a common crutch in the matter as they may agree for this purpose. So you can have a common crutch facility. How it is to be, how much distance it will be, again, that will be a big issue. But still, a provision is made where you can engage a common crutch instead of having independent facilities. And then penalties are substantially increased whenever you create some kind of an offense. Earlier, it is only when an employee dies in the course of accident or anything, it will be only 25,000 was the penalty. Now it is imprisonment with 5 lakhs. Imprisonment is mandatory, and then there will be fine up to 5 lakhs. In case of any further contravention continues, if you fail to provide the safety measures despite of one accident, then it will be extended. In second accident happens, the imprisonment will be for 3 years and fine is 20 lakhs. So they want to safeguard the welfare measures and protect the workers from the accidents. So this is mainly about the accidents causing death, not for the other offenses. Quickly I will conclude. Yeah? Pushpa 2. Another 7 slides. So applicability of contract labor, as we mentioned, now 50. If you have the 50 contract workers, then only the Contract Labor Act applies. Earlier it was 20. And when some states it was made 5. In AP I think it was made 5. So they made it entire country for 50. And even it applies to manpower supply contractor who has employed 50 or more contract labor on preceding year. Earlier manpower agencies are taking some stand. So we are providing only 10 to here, 5 to here, 20 here. Therefore I am not having required number. So that kind of anomalies are now removed. If you engage 50, you are covered. So not applicable to establishment where work is intermittent and casual. So for sudden increase in work, you can engage the contract labor. You got some shipment to unload. So for that purpose, you can engage contract labor. You need not require all these provisions. And license of contract labor is a work-specific license. First time they are giving like this. And then a contractor has to give a experience certificate. This is mandatory. Whenever contract workers goes after the employment of a contractor, an experience certificate has to be issued by the contractor on demand only, or if he demands, to the contract labor, giving details of work performed by the said contract worker. So experience certificate is mandatory. And the third party audit and certification, a provision is made. Already few companies started doing this third party audit certification, not mandatorily by the labor department. Startup companies and other new companies can get their procedures audited by the third party, and their certification can be a valid certificate for compliances. So that provision is made. And the Social Security Fund, as we discussed, is first time there is a fund going to be created for Social Security benefits. Sorry? Recommendation, we'll do it later, not from here. Whoever better, we will discuss. I can't suggest somebody's name from here. We'll discuss. I cannot promote somebody, na? We'll do it later. There are many. So an appropriate government will create a fund for unorganized workers, particularly for the unorganized workers. There will be a Social Security Fund, and then the fund shall be administered and expanded by the welfare of unorganized workers, including the transfer of amount in the fund by other fund established under any other law, for the time being forced for the welfare of unorganized workers. Now these provisions have come because of the COVID. When we saw in the media, many of the unorganized workers traveling kilometers together without any benefit, without food, and nobody was taking care. And there is no fund to take care of these kind of unorganized workers. Keeping in that mind, this Social Security Fund is now created, and now particularly the benefits will be given to the unorganized workers only, not for organized workers. So the fund will be created by the Government of India, and funds will be raised and given to the benefit of unorganized workers. And some amount on each fund will go to a portion of it will go to the Social Security Fund now, hereafter. Now, for all your IT companies, this is a good thing, which prohibits an employee to disclose his confidential information to the other. Now, generally it happens in the senior management level. Contracts, breach of agreements, Section 27 of Contract Act, all those things will be for the senior managers where they are governed by the contract. Workers generally, what kind of confidential information have they with them? They will attend to some normal work and complete their work and go. So they introduced this kind of a prohibitory clause which restrict the workers from disclosing the information, confidential information to the others. You can take action against an employee if he discloses some information to the others, which is a big relief to the managements. But unfortunately, in a manufacturing sector, a small contract laborer, an unskilled worker, what kind of intellectual property he will carry with him? So that is anyway introduced for the first time, and he can prosecute the workers for this kind of a disclosure. Now, this is one big issue for all of you. All of you should issue an appointment letters, including your contract labor, whoever you engage. You can't employ them on a oral understanding. You can't send them on some kind of a understanding that you will be paid monthly this much, daily this much. Those days gone. Now you have to necessarily give an appointment letter, and the format of that appointment letter is also given. You have to give in that format only. So no employee shall be employed in any establishment unless he has been issued with a letter of appointment prescribed in the prescribed format. appended into this rule, provided that an employee who has not been issued appointment letter containing the required particulars shall be issued appointment letter within 3 months of coming into the force of this code. So far, if somebody is given, within 3 months after this code become implemented, you have to give this kind of appointment letter. So no worker will be left without an appointment letter. And what is the format is also they have given. Name of the employee should be there, father's name, date of joining, Aadhaar number, wages including basic pay and dearness allowance, other allowances which are applicable, promotional avenues, and wage period, annual increment, date of retirement, training and skill, EPFO and ESI benefits as applicable, health checkup, nature of job he is likely to perform, leave provisions, provisions of housing accommodation, major hazards associated with the job to be performed by the employee, any other information, signature by the occupier or employer. So if this kind of an employment letter is to be given to a contract worker or an unskilled worker or a daily wage worker, how the companies will survive? Definitely it is going to be challenged. So how can I give a promotional avenue to a contract daily wage worker? I don't know if this fellow will require tomorrow or not. So how can there be a promotional avenue for that fellow? And how can they say that a date of retirement? He may not be continued next month. Even your software company's employees are not aware they are there with the next month or not. Tomorrow, and when pink slip or some kind of slip will come, executives are not aware whether they will be there tomorrow or not. Senior people are not sure that they will continue for a long time. So how can the workers can be asked to be given this kind of date of retirement, what the training you are going to give, what kind of hazardous he is likely to face? These are all stupidity at their height. So you can't give this kind of a letters. Therefore, mentioning these kind of a formats and making it mandatory is nothing but inviting a litigation. Instead of simplifying, they are creating litigation, forcing the employees to go to the court. So because in the light of all this discussion, whether you need to change the policies, procedures, or only wage structure if you change, is it okay? After this discussion for more than 1 hour, do you feel that you require to change your existing practices? Definitely you require to change. The law will force you to change. So not only the worker wage structure, if you have to relook at your HR policies, organizational structure, role and responsibility of every employee, and understand and impact the provisions of this code. So everything has to be relooked, and you have to restructure your salaries also. And if you want me to conclude, it is a consolidation of laws into one book. It is nothing more. The exercise may be viewed largely as a consolidation of rather than a true reform. After 50 years, this is not the expected thing. And the codification of laws does make a huge promise but fails to secure in their realization. This is the reason in the 2019 the act was approved by Parliament. President has given assent. Still they are holding for last 5 years. This is the reason. And failure to incorporate long pending demands of workers and management also does not broaden the frontier of rights and dismantle the long established institutions. That is the difficulty. They have dismantled the existing institutions for no reason. The wage definition runs into 49 lines, which is creating more confusion. As I mentioned it to you in 3 slides, that is running into 49 lines. Even Britishers have not made so complicated. When they made the law, Indian Evidence Act, now they have again changed the criminal laws also. British law has taken care of everything, of every offense which is now happening. Your intellectual property, your theft, whatever now we are calling, everything, moonlighting, everything was covered by the Britishers in their IPC. Except changing the names, we are not doing anything much. Bharata Nyaya Samhita, this kind of a wording changes, nothing is going to happen. And similarly, The worker definition runs into 23 lines. Is it required to define who is a worker? 23 lines is required to define him. And in the process to introduce the provisions, it diluted the existing labor laws. So that is again a big issue. That is all my presentation about these two codes. Thank you for your patient hearing. Yes, sir.